they appealed all the way to the U.S. Supreme Court, which also by then was following winds of political change.
They could have said, wow, it's been 6 years and we can't get it, so we're done. And clearly it was difficult, it was dangerous. To sue your master usually was considered an act of sedition. It took a lot of guts to keep going, and it took 11 years, 5 proceedings.
And as time marched on, the nation's attitude toward these freedom suits was also changing. And unfortunately, the courts were more of a barometer of the winds of the political system rather than justice.
The relative calm that was produced by the Missouri Compromise in 1820 was largely shattered by the 1850s. It was, as we now know, a run-up to a brutal war over slavery. But at the time, things were getting worse and worse. Both sides felt that a Supreme Court decision in their favor might calm the tensions again.
And the Supreme Court decides it in 1857, within days of James Buchanan being the new president. Ultimately, the court decides that because the Scots were enslaved people and because they were African Americans, that they were not citizens and that they shouldn't have had a case go through court at all. They shouldn't have had a case, period.
Chief Justice Taney was clearly consulting with politicians at the time over the decision.
And he worked with the presidency, with the slave owners to try to permanently enshrine the institution of slavery as constitutionally sound. And he made probably one of the worst opinions the U.S. Supreme Court has ever written.
The majority opinion, joined in by 6 other justices, said that there was no jurisdiction to hear the case. And the reason there was no jurisdiction was that people of African descent in the United States, whether enslaved or free, could not be considered United States citizens. And then they went on to find the Missouri Compromise to be unconstitutional because the Fifth Amendment to the Constitution protected property rights, and enslaved people, according to Taney, were property.
He threw out the Constitution, he threw out the Declaration of Independence to write this tiered analysis that there were subhumans without protection and without rights.
The language of the Declaration of Independence is conclusive. We hold these truths to be self-evident, that all men are created equal. The general words would seem to embrace the whole human family, but it is too clear for dispute that the enslaved African race were not intended to be included.
He said that the black man has no rights that the white man is bound to respect. And the decision made all territory slave territory. That actually had ramifications for Minnesota because Minnesota was not a state yet. So for 14 months, from March of 1857 to May of 1858, slavery was legal in Minnesota.